So for the purpose of this class, we're talking about contract. So I guess if you're in 200 level, one of the courses you should be doing is law of contract, and this is very necessary because each and every day people make contracts and people go or enter into one contractual obligation or the other, and it's very necessary because not all contracts that people enter are legally enforceable. Now, in as much as we make contracts every day, you may make contract with a friend to go and fetch water in the stream and definitely does not show up. How do you term that to be a contract, or is it enforceable, or can it be an enforceable contract? That we'll know in this lecture. HL International Limited versus AZ Uzumaka. On July 27, 2020, the court ruled that a contract can be defined as a legally binding agreement entered into by two or more people where duties and obligations are exchanged by one party for the forbearances of the other party. Frederick Pollock went further to say that a contract can be defined as a set of promises or promise which will be enforced by law. Moving further, we also established that not all agreements are contracts, but all contracts are agreements. Not all agreements are contracts. In the form of, you may make a particular agreement with your friend to go to the stream, like I explained earlier, to go to the stream and fetch water, and at the end of the day, he doesn't come. Are you getting me? In that situation, you have not entered into a valid contract, and the reason is because maybe all elements of the contract have not been followed, and as such, maybe consideration has not been established. That cannot be called a valid contract, and as such, you would not sue him for that. Now, all contracts are agreements because all contracts follow the basic essentials of a contract. Are you getting me? And this is because for every contract, there are certain things that must be established for it to be called a contract. The first one is the fact that a contract must have an offer, a contract must have acceptance, a contract must have a consideration. A valid contract must have an intention to enter into legal relations, and a valid contract must have what we call contracting capacities. That means the parties involved must have the capacity to contract. In other words, it means that not all agreements are contract. It means that if I'm entering into an agreement with a minor, that cannot be said to be a valid contract. Are we getting it? That's why the law is establishing that certain elements must be in your contract for it to be a valid agreement. Are you getting me? So further going, we also the contract must not be illegal for it to be established as a contract, and this is what is contained in all contracts. So further establishing this, we said that not all agreements are contracts, but all contracts are agreements. Furthermore, we'll be looking at bindingness of a contract. About the bindingness of a contract, right? In the case of Adewiyi versus MRS Oil Nigeria Limited, it was ruled that the court will not go outside a particular contract that has been agreed by a party in a document. It means that if two parties have come together to agree on something, and that particular agreement has been documented, right, the court will not go outside the agreement of the parties, because if the court go outside the agreement of the party, it will see to lead to anarchy, whereby law will not be enforced. We are saying that in enforcing or making the contract binding, the court or the law will only go as far as the agreement by the parties. Are you getting me? So the court will look into the agreement, what has been agreed between Mr. A and B, and that's what the court will look to enforce. The bindingness of a contract is not in any law or not in any section. It is mostly determined by what Mr. A and Mr. B has agreed. In other words, it means that you see today that most of the time many people feel tenancy agreement. Tenancy agreement is a form of agreement. So if the court is enforcing any form of agreement between you and your landlord, it goes forward to the written document. Are you getting me? To interpret what has been agreed. Are you getting me? So if I'm entering into a contract with you for the sale of a good, are you getting me? And we say the goods, I'm going to sell the goods for you at the price of 500,000. The court will not say no, because this goods is worth 200,000, 100,000. I would do according to what is fair to this other person. No, it will only rule according to what we agreed in the contract. Are you getting me? So in the bindingness of a contract, the court most times look at the bindingness as contained by the agreement of the parties. So secondly, we'll also be looking at freedom of contract. Another was noted as pacta sunt servanda, means that an agreement must be kept. So anywhere you hear pacta sunt servanda is a Latin word for agreement must be kept. In the case of freedom of contract, our established, we also say there are two fundamental aspects under freedom of contract. And firstly is in the case of Statoil Nigeria Limited versus Inducon Nigeria Limited, right? This has established that the court has no power to make the economic agreement for parties. It means that the court will only enforce in as much as to the agreement of the parties. The court will not come and make certain agreements for you. It will only enforce the contract or the agreement based on what the parties have agreed. So the court has no power to interfere or make contract for parties. Are you getting it? Secondly, is the pacta sunt servanda. It means that parties' agreements must be kept. So this is second rule under freedom of contract. So under freedom of contract, as established that the court has no power to make contract or agreement for parties, right? Second, we are establishing that the court will only enforce the agreement made by parties. It cannot go outside the jurisdiction and go and look for extraneous matters. No, it will only enforce a contract based on the agreement of that party. So in other words, it means that agreement must be kept, and as such, every agreement made by one party or the other must be kept subject to that contract. Are you getting it? The agreement must be kept. Now, the only situation where you can give excuse in the absence of fraud, in the absence of durex, in the absence of certain exceptions, the court will enforce all contract. And that's why we say that what we call there's freedom of contract that is based on the parties and not based on law. So the court will only enforce in as far as the parties agree. And this is what I want you to understand under the case of Statoil Limited versus Nducon Nigeria Limited. So contract is distinguished from tort. In establishing this, there's a major difference between a contract and a tort, right? Tort duties are imposed by law, but a contract, they are imposed by the agreement of the parties. That's a major difference, and I need to understand this because in contract, the law or the court will enforce agreement that has been made by the parties, while for tort, what the court will enforce is as stipulated by law. Are you getting it? So this is a perfect example, right? You are going to, you contracted somebody or you told somebody to help you buy or import 15 trucks of petrol or 15 trucks of particular goods that you sell. And in the course of bringing the goods, he was careless about the ship and everything, and the goods fell into the ocean. Are you getting me? What is the contract there? The contract is that I contracted you to get me this good, because this is the agreement that we made by the parties. So when you go to court and tell court that no, I made an agreement with him to get this particular good to me on so day, and he didn't get it, that's what we call breach of contract. Are you getting it? But the law says he also has a duty of care to protect that product and deliver it to you. So that's what we call negligence in tort. Are you getting me? So in tort, it is imposed by law. While for contract, look at the agreement that's been made by the parties themselves. Are you getting it? So if you are bringing a tortious, act to court, you will be saying that, according to negligence, he breached the duty of care. Are you getting me? And as such, he has incurred on himself a tortious liability. Are you getting me? When contract, you say we agreed to deliver this thing on a particular day. This is the agreement, my lord. He has breached the agreement. Are you getting it? So understanding it, that in contract, to talk about the activities based on the parties' agreement. While in tort, talk about the agreement based on the breach of law. So it is law and the agreement made by the parties. Those are the two major differences we get for tort and contract.